The evidence question from July of 2007 is about as elaborate and complicated a test of your knowledge of hearsay as the California bar examiners could come up with. This is a difficult question for a couple of reasons. First, it goes very much in depth into the law of hearsay. And secondly, this is a racehorse question. Doing a sensible, thorough job on this fact pattern in 1 hour is a genuinely challenging task. Have a look at the call of the question. Should the court admit the evidence offered in items numbers 1 through 5, including the work order referred to in item number 2? Discuss. Well, we know what subject we're being tested on here, and we also know basically how we're going to organize it. We'll assign a Roman numeral to each of the 5 items of evidence. Letter A will be logical relevance for each one of them. Then we'll go into all the various objections that come to mind, and finally we'll reach a conclusion. And we don't even have to read the fact pattern to know that the work order that's referred to in item number 2, an item we have yet to read about, is likely going to present issues of authentication and best evidence. So we go to the top of the fact pattern, and we see very quickly that this is not your run-of-the-mill evidence question. At the top, we learn about Dave and his sports car. He brings it in for an oil change, and mechanic notices that the brakes need repair. Well, stop right there. Do you think we're going to make it to the end of this question without a car accident? No, I don't either. In item number 1, mechanic comments to his helper, "David, better get these brakes fixed. They look bad to me." Okay? In item 2, we've got another comment from mechanic to helper. And we also are told that helper never had a look at the brakes, and mechanic makes a specific instruction to the worker about what to put on the work order. And we're also told that helper doesn't currently remember what he wrote on the work order. Okay, well, we're going to have to find a home for that detail. Go to item 3, and we have helper overhearing mechanic tell Dave that Dave needs to get his brakes fixed. In item 4, we hear Dave's reply. "I'm not surprised. They felt a little funny lately." Well, we can stop right there and say that's probably going to be an admission. Then, finally, in item 5, we hear of a traffic accident, and the witness overhears both the accident and the excited utterance of a bystander. Well, we don't really have to read further to get a very clear idea about what the objections are going to be and how at least we've got some idea about what the possible results will be. And I can tell you right now, before we get even 1 minute further into this discussion, that there was plenty of room for latitude as far as the examiners were concerned, as far as the results were concerned. So this question, perhaps more than any other evidence question that we'll look at together, is a question where the least of our concerns is getting our answers correct. These are hard questions, and there's plenty of room for reasonable people to differ. So now let's have a look at the last 3 paragraphs before the call of the question. We find out that the sports car that was in the crash is the one that Dave had just picked up, and we learn about Polly, the owner of the truck, and her lawsuit against Dave for negligence. And we also know her specific allegations. The allegations are that the crash was caused by the sports car running the red light because of brake failure. And Polly says Dave knew or should have known that his brakes were bad and he shouldn't have been driving at all. Polly calls helper as a witness to testify as to the facts recited in items 1 through 5, and she offers the work order into evidence. And then we're told that we are to assume that each appropriate objection was made, but we have to come up with those objections in our answer. And then we're asked, should the court admit the evidence, including the work order? Okay, fair enough. And then we get to discuss it. And we also don't have to second-guess some bench officer here. We don't know what the judge is going to do. We're supposed to indicate what we think the judge should do. Turn the page and have a look at my outline of issues, and you'll see once again, I do absolutely nothing different here from every other evidence question that you're going to read an answer from me about. So, as you see, we've got 5 Roman numerals that correspond to the 5 items of evidence. You'll see in each Roman numeral at the heading level, I am quite specific about what the item of evidence is. But I don't quote from it in the headings. That's what I do when we get to relevance, as you'll see in the answer. But notice that the structure of my analysis here is identical to what you'll see in just about every other answer to a non-transcript format evidence question. For each of the 5 items of evidence, I start off with relevance, and then I get into the objections. And you'll notice, with regard to item 1, the objection is hearsay. With regard to item 2, we have to break it up internally because actually question 2 is asking us about 2 different items of evidence, the instruction and the work order. So I discuss them separately. This is a key organizational issue in crafting a good answer to this question, recognizing that call 2 actually is asking about 2 items of evidence, and so the smart thing is to split them up and talk about it separately. Internally for each one, again, I focus on relevance, and then I focus on the objection, and then finally I reach a conclusion. Interestingly, by the time we're done with items 1 and 2 and part of item 3, ghost item 3, since we've got 2 items in question 2, we've seen nothing but hearsay. And we move on to consider in item 3, mechanic's statement to Dave, again, relevance, and the most complicated and tricky hearsay issue in this fact pattern, the effect on the listener exception to hearsay. That's an issue that's tested pretty regularly on the multi-state, but hardly ever does it come up on essays in California or anywhere else in the United States. So it's great to have a chance to look at it here. And if you didn't do well on it in this fact pattern, join the club. Most of the people who wrote answers to this question had a problem with item 4. And then, finally, item 5, one of the most ritualistically tested issues in evidence on any bar exam in the country, the excited utterance, present sense impression, exception to hearsay. So this is a question that really covers very little new ground. And the new ground that it covers is deep rather than broad. So this is a great fact pattern for reviewing how evidence hearsay issues can be tested. Now let's have a look at my model answer. Here you're going to see this is one of the longer and more dense model answers in this whole program. And the reason is there are plenty of issues here, and I go into a fair amount of depth about every single one of them. Now, please realize, number 1, it doesn't really matter how much you agree with my conclusions. I think probably you'll agree that what I've written is internally consistent, even if you don't necessarily agree with my final conclusion. I can tell you that the conclusions that I present here pretty much are within the mainstream of what good answers to this question arrived at. But the example answers published by the California Bar really weren't identical, and so there's plenty of room for you to differ with regard to the conclusions. Now have a look at item 1, mechanic's comment to helper about Dave's brakes. Notice at the very beginning, I lead with the facts and I explain why the testimony of helper about this comment by mechanic is relevant. Obviously, it supports the plaintiff's theory that this defendant, Dave, knew or should have known that there was something wrong with his brakes. So one thing that you'll notice right up front, this answer has exactly 0 boilerplate. My argument is if you write boilerplate, you get 0 points for it, and not only that, you won't have time to write about what's really at issue. And as it is, this is one of the longer model answers in the whole Master Essay Method series. And you'll notice I invest just about all of my attention on the actual analysis connecting the facts to the law. So now we go into the hearsay analysis. And I think that the discussion of the present sense impression, spontaneous utterance analysis is pretty obvious, and I don't think my analysis is very subtle. If you're going to miss a detail here, it would be the expert opinion of mechanic. And I don't think this is an essential issue at all. But take a step back and think about what's going on here for a minute. The reason we bring a car to a mechanic to have him or her work on it is because the mechanic knows more about it than we do. They're an expert, to some extent at least. And so the idea of considering mechanic's comment as being expert is useful. But notice I point out that there would be a need for some foundation to be presented first. Then I consider the idea that California and federal judges have the discretion to exclude evidence that is more probative that is more prejudicial than probative. And it seems to me that there is some room for one to conclude that it's just not reasonable to allow this evidence to come in. I conclude that the court should admit the testimony about mechanic's comment to Helper about Dave's brakes. So we move on to consider mechanic's instruction to Helper and the work order. And as I indicated when we were looking at the outline of issues to this question, the key thing to do here is to recognize that the instruction and the work order are separate items of evidence that deserve separate analysis by you. Now, as you get into the analysis that I present, I think you'll see that I'm not really doing anything novel, but I am doing quite a complete job, both with regard to reporting on the facts and explaining their relevance, but then going into quite a bit of depth with regard to hearsay and why each item of evidence ought to be admitted. At least, I'm concluding that most of this evidence ought to be admitted. And with regard to mechanic's instruction, the idea that Helper should be allowed to use the work order to refresh his memory in order to allow him to testify about the instruction is another one of those judgment calls where one reasonably could go either way. Turning to the work order, it seems to me that this doesn't really cover any new ground at all. You'll see that I discuss relevance briefly and in enough depth to make it clear. Then I go into hearsay. Once again, I conclude that the court should admit this testimony, and I think the work order is a good business record and thus qualifies as an exception to hearsay. Next, we turn to the statement by mechanic to Dave, and both here and in item 4 with regard to Dave's reply to the mechanic, you'll notice that I go into it in as much depth as I can. But really, I'm not splitting it up internally any more than I have to. For both item 3 and item 4, I discuss relevance, I discuss hearsay in a couple of paragraphs with no further internal headings, and then I arrive at a conclusion. And with regard to item 3, I think the court should admit the testimony, and similarly in item 4, I conclude that the court ought to admit this evidence as well. Finally, turning to item 5, this is an item of evidence that is identical to similar fact patterns that we're going to see before our work together is done. And I cover relevance and hearsay, again in as compact a form as possible, and once again I conclude that the court ought to admit the testimony. And that wraps up a consideration of about as in-depth an essay question on hearsay as you can imagine ever having to face.